It is 1:02 and we're back. We have done our direct cross-board questions, redirect. Are there any, Ms. Bales, are there any other testimony we need to get from your witness?
No,
Do you have any additional witnesses?
I do not.
All right. Yes.
Just real quick back on.
Would you hit your microphone, please? Okay, I forget to.
I've forgotten every single time, so thank you though. Dr. Kirtley, you were asked a question before the lunch break by the chairman about, and I may get this a little wrong, but I believe the question was whether there's any guidance in the statute with respect to the word relationship. You remember that question?
I do remember.
Okay. I just wanted to be clear, the word relationship is not in the statute, correct?
It is not.
Okay, so relationship is in y'all's form, but that's not a word that you took from the statute that's at issue today, correct?
That's correct.
Okay, that's my only question. Thank you.
Board, based on that, do y'all have any additional questions? Seeing none, all right. Are you closed for your case? Counsel?
Yes.
All right. Counsel, it is your turn.
Thank you. Call Tyler Gurse. How do we state your name for the record, please?
Tyler Booth Gurse.
And how are you employed, Mr. Gurse?
I'm employed by Navitas Health Solutions LLC, but I primarily work on providing legal services for Lumicera Health Services.
And you're a licensed attorney, correct? And how long have you been employed by Navitas?
Roughly 5 years.
And during that entire 5 years, has your work been primarily in connection with Lumicera?
Not for the entirety of 5 years, but for the past several years.
And Lumicera Health Services, does it hold pharmacy permits throughout the United States?
Yes, it does.
And how many states is it licensed?
It is licensed in 48 states right now. We will be licensed in Massachusetts within the next month or two.
And where are you? Where's your home base?
Madison, Wisconsin.
And there's been mention of a Paul Page, appears to be general counsel for Navitas. Is Mr. Page your boss?
Yes, I report directly to Paul Page, who is the chief legal officer for Navitas.
And have you had the opportunity to review Mr. Page's affidavit, which was attached as Exhibit F to our petition in this matter?
Yes, I have.
I guess I should be a little bit more clear. The petition is actually in case number 2025-008, but that petition and its exhibits have been introduced into evidence into this matter as well, correct?
Correct.
And you have had an opportunity to review that affidavit?
Yes, I have.
And that affidavit goes through the ownership structure of Lumicera and its parent companies all the way up to the ultimate parent company, which we've discussed at length today, of SSM Healthcare Corporation, correct?
That is correct.
And this is a chart which is attached as Exhibit 16 to Mr. Page's affidavit. Are you familiar with this chart?
I am.
This is the same chart that's been distributed to the board members, so everyone has a copy of this. Can you testify from your personal knowledge that the statements contained in Mr. Page's affidavit are true and correct?
Yes, I can.
And is his affidavit an accurate description of the corporate structure of Lumicera and its related companies?
Yes, it is an accurate description.
And so not to belabor the point, but I think I do need to make a record with respect to that structure. So we'll run through his affidavit and try to do so relatively efficiently. Lumicera is owned by Navitas Health Services, is that correct?
Navitas Health Solutions LLC.
And Navitas Health Solutions is the sole member of Lumicera, correct?
That is correct.
And is Navitas Health Solutions a for-profit company?
It is a for-profit company.
And its operating agreement and articles are attached to Mr. Page's affidavit, correct?
Correct.
Is Lumisera Health Services a hospital?
It is not.
And is Lumisera Health Services for-profit or not?
It is a for-profit.
Is Navitas Health Solutions a hospital?
It is not.
Who are the owners of Navitas Health Solutions?
Navitas Health Solutions is owned 35% by Costco Wholesale Corporation and 65% by Navitas Holdings LLC.
Is Costco a hospital?
No, it is not.
It is a publicly traded for-profit company, correct?
That is correct.
Navitas Holdings, is it a hospital?
It is not.
Is it a for-profit or not for-profit?
It is a for-profit.
That's a limited liability company.
Correct.
Who is the owner of Navitas Holdings?
That is Dean Retail Services Incorporated.
Is Dean Health Services Health Systems the sole member of that entity?
Yes, it is.
And is Dean Health Systems a hospital?
It is not.
And who is the owner of Dean Health Systems?
FPP Incorporated.
Does that have 100% ownership of Dean Health Systems?
Yes, it does.
Is it a for-profit entity?
Yes, it is.
And is it a hospital?
It is not.
And who is the owner of FPP?
That is SSM Healthcare Corporation.
That's the top of the chart, correct?
Correct.
And SSM Healthcare is a nonprofit, correct?
That is correct.
Is it a hospital?
It is not.
On what we've been referring to as the left side of the org chart, SSM Healthcare owns 4 other nonprofit entities and is the sole member of those entities. And those entities do operate hospitals, correct?
That is correct.
Do any of the nonprofit corporations on the left side of this chart, and those are the ones listed in paragraph 19 of Mr. Page's affidavit, do any of those entities have a direct or indirect interest in Lumisera?
No.
Of the entities listed in Mr. Page's affidavit, has any entity other than Lumisera ever held an Arkansas pharmacy permit?
Not to my knowledge.
Of the entities listed in Mr. Page's affidavit, has any entity other than Lumisera ever applied for an Arkansas pharmacy permit?
Not to my knowledge.
With respect to these nonprofit corporations that own hospitals, these are listed in paragraph 19, again, of Mr. Page's affidavit, and are what we're referring to as the left side of the org chart. Do each of those hospitals have their own board of directors?
Yes, they do.
Do each of those hospitals have their own officers? Does Lumisera utilize any of those hospitals' resources in connection with Lumisera's pharmacy operation?
No, it does not.
There was some testimony earlier about a HIPAA officer or a compliance officer listed on a website attributable to, I believe, SSM that was listed as Lumisera's compliance officer. Are you aware of that situation?
I can't speak to the specific document that they identified. I would suspect it stems from the fact that Lumisera does provide operational support for other entities in some cases, in which cases we provide the operational support for a pharmacy that is owned by other entities.
You mentioned earlier you're employed by Navitas Health Solutions, correct?
That is correct.
But I understand that your salary is allocated to Lumisera on the books, is that right?
Correct.
So using that as an example, is there any situation similar to that between Lumisera and any of these nonprofit entities that own and operate hospitals on the left side of the org chart? Does Lumisera pay the salary of any employee of any of the hospitals that are operated by the entities listed on the left side of the org chart?
Not that I'm aware of.
In one of the exhibits introduced by the petitioner, they included an opinion from the Arkansas Supreme Court in Arkansas Hospital Association versus Arkansas State Board of Pharmacy. And in that case, it stated that the purpose of the statute that is at issue today, and that is Arkansas Code Annotated Section 17-92-607. The case stated that the purpose of that statute was to prevent diversion of drugs from one wholesale market, submarket to another. In other words, to prevent a nonprofit hospital from purchasing pharmaceuticals beyond their needs and diverting the excess pharmaceuticals to the wholesale market. Our question for you is, does Lumicera acquire from or dispense any pharmaceuticals that were obtained by the nonprofit hospitals on the left side of this org chart?
Lumicera would not be dispensing any products that were acquired by any of these hospitals under any kind of governmental program.
I'd like to direct you to the 2016 affidavit. If I can, might be easier for me to just pull it in my binders. I have it tabbed and we can look at it together. This is an attachment to the response to petition for declaratory order that the board filed. In the 2016 application, it asks, is there any nonprofit ownership of your pharmacy? In this case, it would be Lumicera. Is there any nonprofit ownership of Lumicera?
No.
The next question is any ownership by or relationship with a not-for-profit hospital? So let's break that down to the two components. Any ownership by a not-for-profit hospital of Lumicera?
No.
And then it asks any relationship with a not-for-profit hospital. Other than the common ownership that we've already discussed up the org chart, is there any other relationship that you're aware of between Lumicera and a not-for-profit hospital?
No.
The 2021 application, which was also attached as an exhibit to the board's response, asks similar questions. It breaks them out. Number one, on page 4, is there any nonprofit interest in your pharmacy? And the answer on the application was no. Is that a correct answer?
I believe that to be correct.
And the second question, any interest in or relationship with a not-for-profit hospital? Would your answer be the same as the previous application?
Yes.
Do you know when Lumicera was first made aware of the board's interpretation of the statute to find that the common ownership by SSM rendered Lumicera ineligible for the license?
My understanding is that it was when we received that memo in mid-2023.
And there were some questions about in subsequent applications where the answer to these questions was in the affirmative. there were questions about why was the answer changed? Do you have an explanation as to why that answer was changed in subsequent applications?
Yeah, absolutely. It was really just a matter of once we understood what their intention was with the question, what information they were looking for from us. It is our practice to be as honest and forthcoming as we can. And in this case, once we knew what they were asking in those questions, we did respond in a way that would be responsive to those questions.
I'll have pass the witness.
Um,
Are you aware of how much business Lumicera was doing under those two Arkansas permits that were issued?
I know there was some business.
If I said it was in excess of $10 million, would that surprise you?
I wouldn't be shocked, but I don't have those numbers in front of me.
Right, and I think you answered the question. You filled out one of these applications that was submitted after the relinquishment of those permits, correct?
That is correct.
And you answered those questions about nonprofit interest. And at the close of the application, you attested that those answers were true and correct. Is that a yes?
That is correct.
That's all I have for this witness.
Members of the board, you have opportunity to ask this witness questions.
I just have one. You said you were licensed in 48 other states?
Yes, sir.
With a pending application for a 49th? Are those all in good?
Yes, sir. Yes, sir.
Are those all in good standing?
Yes, they are.
Okay, thank you.
Are you here today as the corporate representative for Lucera?
Yes, I am.
And so you speak on behalf of Lucera today.
Yes, sir.
And what you're doing, as I understand it, is you're challenging the board's interpretation of the statute, not challenging the legality, constitutionality, or anything else of the statute itself, right?
Yes, that is what's being challenged today.
Okay, so, and that basically boils down, as I understand it, to you contending that there is not a direct or indirect relationship between the nonprofit hospitals in your structure and Lumicera.
That is
Right.
correct. Not for the purposes of the statute.
I'm going to refer to SSM Healthcare Corporation as SSM, if that's okay.
Absolutely.
Is there a direct or indirect relationship between SSM and its nonprofit hospitals?
Yes.
And is there a direct or indirect relationship, interest, let's use the word out of the statute, interest, between SSM and Lumicera?
Yes, sir.
Now, seeing all of these different subsidiaries and the shells that you've gone through or the organizations that you've gone through to present this complicates the analysis of this. So I want to ask you, I want you to assume that SSM has it has two subsidiaries. One of those subsidiaries is a nonprofit hospital. The other subsidiary is Lumicera. Now, is there any interest between Lumicera, in my example, and the nonprofit hospital?
With the way we're organized, I would say no. I think a challenge with cutting out all those entities in between is that it's not as simple as saying they are shell corporations. In fact, if you look at Navitas Health Solutions and the way it's structured, there's actually not direct control of it by SSM. They're not permitted to have that level of operational control over Navitas Health Solutions. It's really more of an investment interest.
I'm going back to my example now. My example is the is the two subsidiaries only, a nonprofit hospital on one and Lumisera being directly owned by SSM on the other. My question, is there an interest in that structure between Lumisera and the nonprofit hospital? Or do having all of these other entities involved somehow change that situation?
I think having the other entities involved does change that situation because of the level of control and interest that they do have in the actual organization.
How many does it take?
I think it's a matter of how much either controlling interest or ownership interest the entity has in Lumisera. By the time you do get down to Lumisera, you're having to go through Navicell Solutions, which does have that kind of firewall built in to prevent that control from flowing down from SSM. In addition to the fact that it's also partially owned by Costco, who also has a level of controlling interest in the organization. In fact, if you look at the board for Navicell Solutions, only one SSM employee is on that board as a chairperson. And since the acquisition by Costco, even that position for the chair is going to be set on a cycle over a period of years. So there's really not that same amount of controlling interest or ownership interest as if it was directly owned and controlled by SSM, in my opinion.
Well, I would agree that you could take steps that would dilute the interest, but does it eliminate the indirect interest? It's still there, isn't it?
Saying, so of the nonprofit hospital in your example, having an indirect interest in Lumisera?
Well, let's go back to my example with just the two subsidiaries. Is there an indirect interest between the nonprofit hospital and the Lucera subsidiary? In my example, now, not in your complicated thing, but
No, I don't believe so. I believe they're two distinctly owned organizations. One is for-profit and the other is a nonprofit, and they are operated separately.
okay, now let's set my example aside and let's go back to your chart for just a minute. Do you agree that SSM inherently exercises control and influence over all of these entities that are on this chart?
I think there's at least some level of influence on the organizations on the chart.
And would you agree that SSM's decisions, strategic decisions, overall vision, resource allocation affects all of these subsidiaries?
I think that depends on the entity in question. They say it impacts it. I think it's hard to say no entirely because any decision made will naturally impact every relationship that organization has.
Is there any point in any of this chart here where there is any document or provision that stops SSM's influence?
Well, I would say the Navicell Solutions LLC operating agreement does drastically limit that influence.
Limits it, but it doesn't stop it, does it?
Not 100%.
Would you agree that all of these subsidiaries have aligned interests and overarching goals that are to meet that are set by SSM?
To an extent, the goal for all of them does follow the basic mission of trying to provide affordable and high quality health services to any patients we encounter.
And would you agree that the success of one of these subsidiaries can contribute to the success of the other subsidiaries?
I don't believe that's necessarily true.
Well, wouldn't you agree that there is a brand and reputation association between these various entities?
Yes, there is.
So if the brand or reputation of one of the nonprofit hospitals was hurt, that could affect one of the other subsidiaries, right?
There is that potential, yes.
And vice versa, if there was something that happened with regard to Lucerne, that could affect the reputation or status of the hospitals, right?
Potentially, yes.
That's all I have. Thank you.
Any other board questions? I was going to say.
I'd like to go back. Yeah, I forget it every time.
Makes me feel bad. Thank you.
Every time. For the last however many years we've had it, I forget it every time. But I'd like to go back to your answers to the question. So I may be missing an application in here. It may have been change of ownership. But in the 2021 application, the answer to the questions related to interest in nonprofit versus, and the second one was interest or relationship in nonprofit hospital. So those are the two questions I'm talking about. So in 2021, the answer to those questions were no.
Correct. On that application, they were no.
Okay. So in answering that question, what did you believe the intent of the board was in asking those questions?
I did not personally fill out this application in 21, so it's hard for me to say exactly what that person would have believed.
Okay, so we'll move on then. So in 2023, is that the application that then you filled out?
Correct.
Okay. So in 2023, then what did you understand the intent of the board in asking those questions?
By that point, the Arkansas Board of Pharmacy had informed us of their belief as to what that what these questions really entailed and like what they were searching for, and that it did involve the entire string of parent companies. Whereas before we did not necessarily interpret it to mean that. In our experience with most other states, in the event that they do want that information on the parent companies, they are specific about asking about any direct or indirect interest.
And didn't it say direct or indirect?
On the 2023 application, it may have.
Okay. So the difference then between the two is your interpretation of what the intent of the board was.
Our understanding of it.
So help me understand what the difference in the understanding was, because you went from a no to a yes. That's a completely, in a dichotomous response, you did a 180 in answering the questions, and not only once, but twice. And so I mean, what changed other than your interpretation? I mean, what literally changed? Be able to answer that yes versus no.
It really did just come down to what the interpretation provided to us by the Arkansas Board of Pharmacy was. Once we knew exactly what they were asking and what information they were looking for from us, our responses to those questions changed to align with what we knew they were looking for.
Thank you.
Do my online members have questions? You got your hand up, you're up.
Yes, I just have one. I can't remember the exact question, but someone asked you if Lumisera would purchase any drugs from the hospital. That's the boiled down version. And you said not for a government entity. Why did you clarify it like that? Do they purchase other drugs from them? Why did you answer it like that?
All right, I guess I had misheard that question slightly. They do not purchase any drugs from the hospitals themselves.
You just added that caveat.
The
just
governmental entity
because?
part came in. I know that's the drive of this statute, is to prevent diversion of products. So I wanted to be clear that Lumisera does not in any way derive benefit from these hospitals' ability to purchase drugs either through 340B or any other government programs where there is that discount.
But they don't actually purchase any drugs from the hospital, period, the end, ever.
Not to my knowledge.
Okay.
I had the same note, but to go a little, are there any shared resources at all? I know that you mentioned that the HR, or not HR, the HIPAA officer, you didn't think was a shared resource, even though it's listed online, but is there anything that touches between the hospitals and Lumicera in terms of financial anything?
Not to my knowledge.
Any other questions, board members? Seeing
Appear
none,
at this moment.
do what?
Doesn't appear at this moment.
All right, redirect.
Nothing further. Thank you.
Based on the board's questions, does the board attorney have any questions?
No, we do not.
All right. Call your next witness.
Respondent rest.
All right. It was grouped up. Closing arguments. Counsel for the board.
Briefly, board members, I think you have all the facts in front of you. And it's our contention, and I think we've proven it through Dr. Kirtley's testimony and the documents that are readily available on the internet, that are also in the exhibits, that there is nonprofit interest with Lumicera. And they answered those questions on the 2016 and 2019 applications. They misrepresented that interest. Because of that, it put the board in a position, now we have a complaint, and it looks like we issued these permits in violation of that statute. And then the other applications, the answers changed. And those answers, I think, that were provided by Mr. Gress, those are the correct answers. So if you're asking yourself, does Lumicera, is there nonprofit hospital interest? I think the record is clear on that. So we're asking that you make a finding that Lumicera acted with misrepresentation in those applications in 2016 and revoke any permits or their ability to seek a permit in the state of Arkansas and levy any disciplinary action you would like to assess in this matter.
Counsel.
Thank you. Members of the board, thank you again for your time in hearing this matter today. I know it gets in the weeds with all these structures, and as Mr. Simpson pointed out, the structure here is very complex. I'd like to go back to what I call the charging document for this case. So right now, we're only looking at case 2023-124. And the amended order and notice of hearing sets out the charges that are alleged and are at issue today. And let me read those so that we're focused on what the charges are before this board. Charge 1, if proven true, the allegations described above in paragraphs A1 through A11 demonstrate that applicant is ineligible to hold an Arkansas out-of-state pharmacy permit pursuant to Arkansas Code Annotated, Section 17-92-407B. Charge 2, if proven true, the allegations described above in paragraphs A1 through A11 demonstrate that applicant is ineligible to hold an Arkansas out-of-state pharmacy permit pursuant to Arkansas Code Annotated, Section 17-92-607A, and is not able to sell drugs and medicines at retail into Arkansas. Charge 3, respondent, as described in A1 through A11, shipped numerous prescriptions into the state of Arkansas from on or about May 2nd, 2016 until current, with a license obtained by fraud, deceit, or misrepresentation in violation of Arkansas Code Annotated, Section 17-92-407B, and Arkansas Code Annotated 17-92-311A1 and 6. Those are the charges that have been levied against Lumicera and are before the board today. We have two defenses to those charges. First, we don't believe that the board has correctly interpreted the statute at issue. The statute doesn't talk about relationship. The statute doesn't talk about control. The statute doesn't talk about aligned interests. The statute says interests, not aligned goals or reputational effects of one entity on the other. It says interest. There is clearly no ownership interest in Lumacera by a nonprofit hospital. That's been admitted and is not at issue. The ownership of a parent company of other entities that then own nonprofit hospitals is simply not enough. The statute speaks to an interest. That is not an interest. It may be a relationship. There may be a relationship. There may not be, but that's immaterial to the issue before the board because there's not an interest, and an interest is what is the word that the statute chose to use, direct or indirect. There is no interest. If I own Acme Brick Company and I own Castleberry Farms LLC, Acme Brick Company does not have an interest in Castleberry Farms LLC. I've got an interest in both of those entities. Those entities do not have an interest in each other. And that's what is at issue here. We have entities who have common ownership. Common ownership in and of itself is not enough to create an interest in the pharmacy by the nonprofit hospitals. So that's defense number one. We simply don't believe that the statute applies to preclude or prohibit Lumacera from obtaining a pharmacy permit in Arkansas. If you assume for purposes of argument that defense number one fails and that the statute did prohibit Lumacera from operating within the state of Arkansas, the question then is whether or not Lumacera, as alleged in charge 3, obtained its license by fraud, deceit, or misrepresentation. I submit to you that even in that situation, the charge fails. Black's Dictionary defines fraud as a knowing misrepresentation or knowing concealment of a material fact made to induce another to act to his or her detriment. Black's Law Dictionary defines deceit as the act of intentionally leading someone to believe something that is not true. It defines misrepresentation as the act or an instance of making a false or misleading assertion about something, usually with the intent to deceive. All three have an element of intent. You heard Dr. Kirtley testify that he cannot offer to you an explanation for what was in the head of the person filling out these forms. I asked him if it's possible for the person who filled out these forms to have filled them out in good faith and answered the way they did. And his testimony was, I don't think so, but I don't doubt that the person who filled these forms out thought they were filling them out correctly. If they thought they were giving you truthful answers, then they were not intending to deceive you. In order to chin that bar, it must be proven that Lumacera answered no on these forms with the intent to deceive this board. I don't believe there's any proof to that effect. And I think to find proof to that effect, you would have to assume that Lumacera knew that the statute was being interpreted in a way that is inconsistent with the plain wording of the statute, as I've already argued before. So it's our position that the statute means what it says. There is no nonprofit hospital that has a direct or indirect interest in Lumacera, and therefore the charge should be dismissed. Even if that is wrong, the board has failed to prove any intent to deceive by answering these questions in the way that they were answered back in 2016 and 2021. And so there is no need to punish Lumacera for acting in good faith and answering the questions in a way that it deemed appropriate. So based upon the testimony we've heard today, an argument, again, thank you for your time and ask you to dismiss these charges.
All right, thank you for your closing statements. At this time, we're going to go off the record for the board's recess for deliberations and a decision regarding the findings of fact, conclusions of law, or any penalties or non-penalties as they decide. Once the board reaches a decision, we'll go back on the record. With that, we'll be off the record.
Hey, are y'all talking?
Yeah.
Not yet.
Okay. Sorry.
It's just very quiet in here. I think there's. a
I'm
lot
not
of
used to it
people-
being that quiet.
Y'all hear me? Okay.
Yes.
Gosh, I'm one of these little people who like to watch this genealogy stuff. And one of the shows that I even watched last night was Finding Your Roots. The root to this organization all goes back to SSM Healthcare Corporation. That's I don't know how many grandparents back or great-grandparents back it is, but everything points back to this organization. And that is where I see these organizations being kin to each other. And so we have kinship established. Same family branch. And my thinking is that these companies are all related. And there is a connection to this organization and the hospitals. And looking at the chart, even the chart that they brought in, it would, and it's just right here, right on paper. We can all see that relationship.
Thank you. Harold, maybe just for clarification a little bit, and this may be the wrong use of the word, but maybe it conveys the thought, is so there were allegations, but then the last thing that was discussed was intent. Can there, absent intent, can there still be strict liability that they still incorrectly or erroneously filled out the application and got a permit as a result of it? Can that allegation be found to be true and stand on its own absent the fraud or the intent part?
Well, two thoughts on that. First, Mr. Castleberry went to fraud. That's one of the elements. Another one is just plain misrepresentation. With regard to intent itself, that's one of the difficulties you get when you end up having, let's say corporate, that includes partnerships and LLCs and so. When you have a corporate applicant, because how can you ever say what the intent of a corporate applicant is? You know, do you look at the person that filled out the application form? Do you look at the person standing behind him saying, fill it out this way? Do you look at the intent of the person who assigned it to somebody that was kept purposefully ignorant of the situation in order to fill it out? It's difficult. So it's very difficult to find an intent in a corporate situation like that, absent a clear smoking gun. But I think it just seems to me that they had reason to know what the interpretation was and answered the question in a way that didn't meet that interpretation. Now, I will grant you that their interpretation is arguable. And unfortunately for them, it's an interpretation that's been made and made consistently. And so I don't know. I don't know how to answer what you're asking any more directly than that.
Harold, I have a question for you too, because so the analogy that he gave with that, if he owns Acme Brick and he owns Castleberry Farms, I believe, he has an interest in each of them, but they do not have an interest in each other. made sense to me. So can you explain to me legally, because I don't understand the term interest and it sounds like there's a lot of leeway in it. So can you explain to me how that statement does not apply to this situation?
Then repeat the statement that you're wanting to apply one more time.
So his argument was if he owns Acme Brick and he also owns Castleberry Farms, that he has an interest in Acme Brick and he has an interest in Castleberry Farms, but Acme Brick and Castleberry Farms do not have an interest in each other. Is
Well,
that
you can come up with examples where that in fact could be true,
okay?
where what happens to one has no effect whatsoever on the other. But it could potentially have an effect on reputation, for example, about what's the reputation of the businesses Mr. Castleberry runs. I'm not saying he does this, of course, but
Sure.
but say he was caught doing something improper. To what extent would that have an influence? And what if one of his entities, Acme Brick, say, was caught doing something that was improper? Would that have an effect on what the farm would have? So I think that there are aspects of that argument that hold true, but they don't necessarily hold true. And it's particularly complicated in this situation where you have so many different entities going in so many different directions.
And we do have clear precedence with the one from Amera something. Correct?
I'm sorry, say it one more time.
We have clear precedence from the Amera.
Yes.
Med.
Okay.
I mean, I think
Thank
our
you.
interpretation has been that's a sufficient interest to apply, to interpret the statute that way.
And the judge said that shared ownership constitutes interest. Am I?
Yes, I think that's right.
Thank you so much.
And I will just add, from working with a lot of different boards, every board does kind of look at this in their own way. I mean, not 100% their own way, but they have some boards care about the grandfather's grandfather, et cetera. And this board, from the whole time I've been here, and John can certainly correct me if I'm wrong, but has looked at this issue, not just hospitals, but looked at what information they needed all the way up the chart to provide the application. And I think because they look all the way to the top, they do see this SSM at the top. So I think it's just, the board has interpreted it this way, and it's been petitioned and gone through courts to find out that this could be used this way. So to me, it seems like we're following what we have been following for years.
So is there any other board discussion? And then the next question would be is like, what are y'all thinking to move forward with?
And can I speak? And this is something that's been going on for years and years. I've been on the, in this position for a long time, and periodically, we'll have companies come up and the genealogy chart tells the story. If you can trace it back to a parent company, they are kin to each other, and there's vested interest on both sides. Come to the same conclusion.
To me, the question is, I've been on the board for 5.5 years. This has never come up. I'm not aware of board precedent, and I certainly wasn't aware of that Supreme Court case. So to me, the question is about their intent. And to me, that's what we're making a decision on, because that's what they've been charged with. Did they intentionally defraud the board in filling out their application? And we're also dealing with very nebulous concepts of indirect versus direct interest and what the definition of a relationship is. And in fact, I would say perhaps if I was filling out that application, I might have been confused about that. So I would have a hard time finding disciplinary action on a permit holder based on a lot of nebulous definitions. I don't have an issue with the board's interpretation, but that's not what I feel like my decision's based off of. It's based on, am I willing to charge them with fraud, deceit, or misrepresentation based on how they filled out the application? And factoring all that in, I don't think they should be expected to know what board precedent was or what board thoughts were, because they're not going to be privy to that knowledge. And so for me, those are my thoughts. I just wanted to share that before we go to a vote.
Oh, can I add one thing? And I don't know that I'm disagreeing or you're agreeing either one, but everyone that fills out an application, whether it be a person, a company, or a manufacturer, or anything that gets licensed, while it might be hard to understand what the question means, we fully expect, or have for the last 8, 9, 10 years I've been on here, however many it has been, that they understand the question that they're answering. So while that question could be a little strange and you can understand their side of the argument, I just feel like it's their requirement, the applicant, doesn't matter who they are, to fill the application out correctly. And if they had a question, they need to call and ask. I mean, we have people, pharmacists, technicians come before us all the time that say, well, I didn't think it meant that, so I put this question, this answer. But that's what we're saying, in a sense, that's the same thing here. They misrepresented. Now, did they fraudulently deceive it? I don't know, but they did misrepresent what their organization is. Just another thought to go with
And
yours.
to that point, I don't think they would have been issued a license if they had answered
Right.
initially the way that they have at this point.
Leaving the question of fraud aside for a moment, let's say that there's no fraud. Are they, if our interpretation of the law is correct, are they entitled to have a license?
No.
No. That, to me, that's not a question. I'm talking more about the questions themselves.
Right, but
And I understand what Dr. Mack was saying too. I guess I'm coming at it from the standpoint of, can be filling out an application and think you're answering in good faith without intent to defraud and misunderstand the question.
sure.
That doesn't imply fraud or misrepresentation. It's a misunderstanding.
Well, let's assume you're right about that, that there was no fraud, that was just a misunderstanding, totally innocent, all of that. If our interpretation of the law is correct, are they entitled to have a license today?
Well, then are we being asked to make that decision right now?
Well, I guess that's a question I have too.
I don't feel like
is that question in play?
that's not been presented.
I mean, it's one of the charges.
Well, it's one of the charges. Right, but they revoked their, I mean, they gave up their permits. They have a new application. That may be what we're about to talk about in the next one. I don't know. I don't know the answer to your question, Harold. Because it hadn't been, the argument hadn't been made, when they closed. I don't think Mr. Castleberry made the argument that they should be granted their permit today. So I don't know that that's
Yeah,
what we're.
the way I would phrase it is, let's just assume total innocence in filling out the form, all of that. But we've got the facts of the relationship that we've interpreted, not relationship, but the interest that they have that's sufficient to make them ineligible. What happens now? Where do we go from there? That's what I don't
I think
understand.
board precedent does take place around the decision on whether to grant the permit. I think that's where you have to take into consideration what the board has historically done, and that's probably where the Amerimed or whatever the name of the case was. I think that's where some of that comes into play. So
Could we get clarification perhaps from the agency and even the applicant on, since we've got the two processes going simultaneously, to clarify where we are and what options are open, what's on the table?
yeah, I mean, I think it's important to understand because, I mean, again, I'm looking at it from the standpoint, like I'm not making the decision on whether they're eligible to hold a license, being asked to make a decision on whether they intentionally misfilled out their application in 2016 or whatever the year was.
Okay.
So,
C1
Let's say we
charge
decide
says
that.
they're ineligible. C1 charge says they're ineligible. So I have a feeling we're looking at all of that, but
Well, it sounds like y'all have a question about the charges. Am I understanding that correctly? Okay, so are you understanding that this is the board's question also, counsel?
I do understand the question, yes.
You understand? All right, we're gonna go back on the record for a moment. So if you would, we're gonna be back on the record, and this is to make sure we have a good record for you. The board has a question related to the charging document. I believe that the specific charges are listed as C1, C2, and C3 of the amended complaint on page 4. So if you would ask your question of counsel and give them an opportunity to speak on it, and then we can go back off the record for continued deliberations.
I guess what we're asking is, assuming you take the fraud misrepresentation question out, are we in a position at some part of this proceeding to make a decision regarding eligibility as of today, given our interpretation?
Yes, sir. So if you look at charge C1, that alleges that they're ineligible to hold an Arkansas out-of-state permit. And the ineligibility would be based on the statute, 1792-607A, which we've talked about all morning, but it's the nonprofit interest. So my argument on that would be yes. C1 allows you to decide that Lumisair is ineligible to hold an Arkansas out-of-state pharmacy permit. Now, C, and maybe I'm overstepping and answering a question you haven't been asked. But C3 basically says they received their permit, they shipped numerous prescriptions into Arkansas under those permits, and they misrepresented their structure. And that's why they had the permit. Had they not misrepresented their structure, the board would have been unable, due to 1792-607, to issue the permit. Fraud, deceit, we don't have any specific proof. As Mr. Simpson said, I can't get into the minds of the person that fills out these applications. We can't really investigate. We don't pick up the phone and call, hey, were you sure? What are you thinking when you answer these questions? But we do consider that to be an absolute misrepresentation of the nonprofit interest. And that 1792-607 addresses.
So to follow up on that, and Mr. Castleberry, feel free to comment too. I'm not trying to go just to the agency on this, trying to understand what our options are. If we would say find C1 and find C2, what would the possible results from that be?
They would be ineligible to hold an Arkansas pharmacy permit.
And there's a current application that we would be denying?
No, you would just prevent them from holding an Arkansas permit in the future. They relinquished their permit. The applications after the relinquishment were returned. Well, there's not a We're not asking for a vote whether or not to approve or disapprove their application. We're asking for you to hold whether or not they're eligible or ineligible under the evidence been presented, whether ineligible or eligible to hold under 1792-607A.
Well, let me ask it a slightly different way.
Okay.
If we were to find C1 and C2,
Mm-hmm.
we've got certain actions that could follow from that. What would be different as far as possible actions that would flow if we found C1, 2, and 3, found all of them?
What would be the possible?
Is there a difference between what actions are open to us if we found all 3 instead of just the first 2?
No, I mean, if you look, and maybe it's time to pull out the law book that's on your tablet, but if you look at 1792-407, that allows for the non-issuance or revocation of a pharmacy license. And then we also have charged under C3 1792-311A, which allows for alternative sanctions for holders of permits, which they were at the time. Does that help at all?
Commissioner, if I might ask a question that might help. And I'm just trying to understand this. It looks to me that C1 and C2 are charges that would prohibit them from having licenses in the future, correct?
Yes, it would, the ruling would be they're ineligible to hold an Arkansas pharmacy, out-of-state pharmacy permit.
C3 would hold them punishable, would impose penalties for their holding the license during the 2016 to current. Is that correct?
Yeah, based on if the board finds the misrepresentation.
So.
And it gives alternate sanctions, or also would allow them to not revoke, would not allow us to issue the permit.
Okay, so really C3 is looking at the period that they were in operation in Arkansas.
Yeah.
C1 and 2 is looking prospectively saying if this is the interpretation of the board, they're ineligible to hold a license.
Correct.
Okay.
And I think that's from May 2nd, 2016, when they had that permit that we're alleging was issued by misrepresentation.
Okay, thank you. Did that help the board?
Okay.
Yeah, would you like to?
Yeah, may I just Mr. Sips, I think the way the hearing officer just described it is exactly right, that C1 and C2 go to the interpretation of the statute we've been discussing. And if the board's interpretation of that statute is consistent with the charging document, then the board would find that Lumisera is ineligible. And then C3 is really more of a request for punishment, if you will, for dispensing medications in Arkansas by or pursuant to a license that was obtained by what they claim were misrepresentations on the application.
So your closing argument, your first argument would apply to C1 and C2, and your second one to C3.
I think actually my first one applies to all 3.
Right.
And my second one just applies to 3.
I
Yes.
Anything else? Counsel for the board, anything else?
Not unless the board has other questions.
All right, we're gonna go back off the record then.
Please. So to clarify, because I don't think I was clear earlier, what I was speaking to was allegation 8 and charge 3. Those are the things that I'm struggling with finding true and proven. I agree with charge 1. I agree with charge 2 based on current statute and board precedent. They're not eligible to hold a license. So sorry if I wasn't clear on that earlier.
So if I can add to that too, looking at 8, which we're talking about in 3. Once again, I think you could kind of be on this side or the other, every application we see, but they were asking, I can't remember the exact question. They've gone over 100 times a day. I should remember, but the question on the application, it's kind of like, have you ever done this or that? It seems like even at the lowest thing, it might just be misrepresentation, not really trying to fraudulently get the license. But I think everybody that's kind of done business in this state has known that this was one of probably many states that don't allow this nonprofit thing to go on with hospitals. So, they knew that SSM was on top of their parent thing. And when you send everything into the board on your application, you're having to show all of your levels of ownership and by how you answered the question. It just seems to me like they did misrepresent, or they wanted to misrepresent or tried to misrepresent. It seems very obvious, the fact that they wouldn't have gotten it if they'd answered correctly. So that's where the misrepresentation comes to me of, if you answer it one way, you won't get it. So go ahead and answer the other way, and that's it.
Are we still off the record? Just a straw poll. Does everyone agree that C1 and C2 are approved? Is there any dispute on that? How do we feel about C3?
Did you get your answer for that?
Mhm.
I've already given my answer, so.
Okay, C3 is just a progression of C1 and C2. So that's, it would be there, C1 and C2 had to happen.
Well, Dr. Kirtley indicated he didn't, or we couldn't show intent.
I would,
Well, misrepresentation would be false or misleading. I mean, is that not the definition of misrepresentation?
well, I think as much as I hate that, I think I would have to find 4 or 3 on the basis that's the approach that we take with pharmacy tax.
On every,
Filling out the forms. And I don't think we can make an exception for large entities.
I agree. We've looked at every application and their answers in that form.
Isn't there a difference though in the form where it, like for the technicians or pharmacists or whatever, where it has in parentheses, like even if it's been expunged, like spelled out to the letter, like the definitions are very clear in that one versus this question of defining interest, and maybe they did not like legitimately know what defined interest in this case. Is that not a difference?
Well, a technician is, because they all were saying the same thing of, I didn't know that it meant this or this, so they made it a little more clear. But for an entity that has gotten licensed in multiple states, they have seen this question asked in probably 50 different ways for 50 different states, and I think they have 48 states. So it wouldn't be that unknown to an entity versus a technician, I think.
But the
we-
other states licensed them.
Possibly in this format or not, but a lot of them don't have this hospital bill that Arkansas does. So, but I mean, they all want different things and they ask different things in their questions. They're getting.
That's my point. I have a hard time saying that they for sure knew that they were answering this knowingly, falsely, or that they for sure understood, like that the answer was clear, because we've had so much debate on what it meant anyway. That's a hard one for me.
Yeah, it is. It's just. I agree. It's very hard. And I think we need to think about it as far as anybody and everybody can come say, well, I didn't know you meant that. So I didn't mean to misrepresent. So we just have to be careful. I don't know the right or wrong answer. I'm just saying, let's think really hard about how we look at this.
Mr. Chair, if I might, Just one of the things I would advise the board of is that the testimony, the decision you're making is based on the testimony and evidence that's presented here today. And so that's what you're limited to when you're looking at this. And you might want to consider breaking this up into separate votes on these, since it sounds like there's some debate related to the third issue, so that we can have the proper vote on that issue, just as a suggestion for you when you're moving forward for consideration.
Maybe we could do a straw poll and just go charge by charge and see what everyone's in agreement on. So just so that I can get your response on Zoom, maybe we could do this by just show of hands. So among the board, who believes that charge one has been proven? Okay. Likewise, who believes charge two has been proven? Okay. Regarding charge three, I want to break it down. Who believes that they have been deceitful in their application? Okay.
Can I ask a question in regard to that?
Sure.
Okay. I think there are different levels of misrepresentation. That there's an innocent misrepresentation, and then maybe a willful,
Okay.
and then maybe a fraudulent kind. And I don't know that what I see here seems intently fraudulent, at least not that I've had proven to me at this point, but definitely innocent misrepresentation, maybe willful misrepresentation. And are those all, I think that might be dealt with in regard to the level of the punishment. If we.
So let me continue the same thought then. So I don't think that'll change my question regarding fraudulent. So does anyone on the board feel that they were deceitful in their answering of the application? Okay, and then I'm going to take Dr. Foucher's advice, and we're going to break misrepresentation up. Who feels that they misrepresented in a innocent sort of way? In other words, it was not their intent to be false or misleading. So I'm going to ask you to assume that misleading or misrepresentation means false or misleading. So who of you feels that they misrepresented in a non-false or misleading way? Okay. That's what I'm trying to get at.
Yeah, it's hard to gauge, but, still, if, 1 and 2 happen, then 3 is the results of the things that happen in 1 and 2.
Well, and that
And
went
how
back
do
to
you-
my earlier question that
Yeah.
I had for Harold was, can there be strict liability? In other words, can you answer 1 and 2 erroneously, that it'd still be wrong, but you didn't do it on purpose? And so that would seem to differentiate between the charges 1 and 2, which really I see together. One is a permit and the other is the fact that you can sell drugs pursuant to it. So it's in our traditional sense of what we're considering a pharmacy.
Well, I would look at it really simplistically.
Okay.
One, was it a representation? Yes, they answered the question. Was it wrong? Yes. Therefore, it was a misrepresentation.
I agree.
There's no standard for innocent or guilty or whatever. It was a misrepresentation. And that's basically the standard that we hold everybody to when they answer questions incorrectly.
Okay, so say that again, because it would seem that in the context here that misrepresentation would have a fraudulent connotation to it.
Well, let's carry it to the next step. Did they obtain a license that they wouldn't otherwise have gotten by that representation? Yeah.
Yeah.
So I think it fits.
So you believe that in order for them to have gotten a license, they had to be false and misleading to get it?
They had to represent what they represented. And if they had represented what was true, they would not have gotten the license. So
Well said.
So let's ask the question then. I'm just going, you all define it however you define it. Do you believe that they were misleading or misrepresented the application when they made it?
Yes.
I'm still a no.
Okay.
I think in order to misrepresent, you have to understand the question. And like I said earlier, I think when you go to the statute and you look at direct and indirect interest, we've established there's no definition of that. It's nebulous. Representation on the application form is nebulous. And again, I think you have, I respect your definition. I guess my definition is just different. So.
Well, I'm not quite sure where we stand on this. I don't have a vote unless there's a tie, so.
Did you get a vote of where we were on C3?
Yeah, I think there was a majority in favor of C3 also. So
All right, so then I guess that leaves us then with C1 and C2, that's going to leave them without a permit. There's no doubt about that. C3, then is there any form of punishment that you deem is due as a result of the fraud, deceit, or misrepresentation?
I believe there was great benefit derived by the permit that was obtained in a fashion that it shouldn't have been. And from the numbers that I believe Ms. Bales mentioned, that could be as much as 10 mil, was it 10 million a year? Okay, was that over 10 million? If that was a year, then that's even a much larger number. So I mean, we're talking about a fair amount of benefit derived from it. I don't know what you do with it at that point. The baby.
We have to go back on the record to ask her that.
$10 million was the
Want to
number.
go back on the record to ask
So
her
we go
that?
back on the record.
Really, the evidence.
part of the problem is the evidence is closed at this point, and the testimony was 10 million. Unless there's an objection to going back and getting clarification on that. But really the record is closed as far as the evidentiary portion of it.
Yeah, I mean, I would object to reopening the record, to adding anything on that. I mean, the record's closed, and I think it was also a question of range and estimate as well. I mean, that information is a knowable number out there, and that was not presented into evidence.
And my record, what I wrote down was that he agreed that it was probably over 10 million, but there was no time period granted on that.
Right.
So I believe that's the evidence that's in before you.
So it's a substantial amount, and so we could go from there.
What was that, Dr. Mack?
I was just thinking it is a substantial number was mentioned, so I guess we could look at it from that without, since that's all that's in the record.
I guess I would have a question on what limitations are we under with regard to monetary fines or penalties?
We're going to go back on the record for a moment. I believe the board has a administrative question for staff. If you would go ahead, since we're on the record.
Yeah, my question would be, what options are open to the board from a fine or monetary penalty viewpoint, assuming we were to find C1, 2, and 3? And I say that with regard to C1, 2, and 3, because I don't know if we're talking about per prescription or some kind of a limitation in it.
Your mic is off.
Today. So we've got C3 charged under two provisions of our statute. The first one is 1792-407. And it's technically B. Whenever a person, firm, partnership, estate, corporation holding any permit issued under this subchapter attains a permit by false representation or knowingly violates any pharmacy laws, the board shall revoke the holder's pharmacy permit. So that's, in this case, again, refers back to you wouldn't allow them to have a permit. Then under 1792-311, we've also charged it under that, which gives you alternate sanctions that you've seen before in all of those other cases that we've had. It's 311-6. Person's been guilty of fraud or misrepresentation and obtaining a license to practice pharmacy in the state of Arkansas. And you go down to, you can do fines under the statute, no less than $5, no more than $100 per violation. 1792-312 is what I'm reading. I think that's what I emailed you about last week as well. Alternative penalties also provide a monetary fine, education programs, licensing examinations. I'm not sure any of those would be applicable in this case. Place restrictions on the activities of the holder, and any other requirements that the board feels are appropriate. That's under 1792-315, the alternative penalty. So those are the options the board has. If you determined under C1 and C2 that they couldn't have a permit because it would be a violation of the statute regarding the interest, then your finding might be that they are ineligible to hold a license or reapply.
But as far as a monetary penalty, we'd be talking about how many violations, more than one, and $100 per violation?
Yeah. Ask that one more time.
What was the monetary limitation that you mentioned? I thought it was $100 per violation.
Hey, Officer, may I interpose an objection?
Yes.
So
Let me regroup.
That's on adulteration.
two things. With respect to monetary
gotcha.
penalties, the two statutes that we were charged under, 1792-407 is entitled revocation, and it provides for no monetary penalties. 1792-311 is entitled license revocation, suspension, refusal to issue -reasons. It provides for no monetary penalties. There's nothing in the charging document that seeks monetary penalties. I don't believe it's appropriate to impose monetary penalties when we were not put on notice in the order that would be sought. And to the last question that was asked with respect to a monetary penalty per instance or transaction, there's no evidence whatsoever in the record about the number of transactions. So I don't believe it'd be appropriate to issue a monetary penalty in any event, but in the event that the board or the hearing officer disagrees, it would not be appropriate to base it upon number of transactions when that's not in evidence.
Counsel, hang on a second. Counsel for the board. You have a response?
Well, you're charged under 311. Let me look this up again. And that's a charging allegation. The penalties are always available to the board members under 1792-315. So these, the charges are violations of those statutes. The penalties are available to the board. And that's under 1792-315. And that's $500 for each violation.
Okay.
And education, other things that I'm not sure you would do in this case, but there's lots of options that are always going to be available to the board under the statute.
So for the purposes of what we're talking about here, the monetary penalties, even if available, would be de minimis.
I mean,
There's been what, more than one violation or just one violation?
So
it
if,
would-
if I may, I think counsel for respondent is making an interesting point in that the charging document is on these on the 311, and then counsel for the board is talking about the alternative penalties under 315. And as I understand it, monetary penalty not to exceed $500 per violation. And then under C3, they're saying that shipped numerous prescriptions, the specific number of that has not necessarily been in evidence. There was a value that was placed on it, but there hasn't been any specific number, if I recall the testimony. So I think ultimately the board has the ability to impose a fine under the 1792-315. And with that, I'm going to overrule your objection and let the board move forward.
But do we have proof of more than one violation, or are we just limited to $500?
So there were two applications that said no.
Okay, still,
So there's two.
sorry, I can't get excited in this case about $500 or $1,000.
Yeah,
I'm just answering your question. That's the only thing that I know of that we can enumerate.
And the evidence was that there were transactions, the number of which was not identified. There was a value of transactions, whether that was 1, 2, or a million was not in evidence that was provided. But there are violations associated with the documents, as the chair was pointing out.
So if I'm understanding correct, other than that, that leaves us with the choice of some future limitation on ability to apply. Is that?
Sorry, we're still on the record here. Is that a question to me, sir?
Yeah, let's ask that.
I think you're going to have to re-ask that question.
Is one of the options that's available to us to condition future applications or restrict future applications?
right, I think, yes, definitely, you would make the finding that they're ineligible. Which means, that we would not be able to issue them a permit, which is where our position was, to begin with. Because it's violative of 1792-607. So that is an option. If you find charge C1, you would find that they're ineligible under law to hold a permit. Same for C2, ineligible to hold a permit.
Counsel, Mr. Casper, you want to respond to that?
I have nothing to add to that. Thank you.
Are we ready to move? Do we need to go back off the record for any more deliberations, or is the board ready to move forward?
I think we need to deliberate the action we're going to take.
We're going to go off the record then.
Clear on if there's a monetary penalty available to us or not, so I'm not clear if there's a monetary penalty available to us or not, so I would say, patients being through the charters proven, hold or apply for a permit.
And regarding whether or not they could hold a future permit or not, I mean, that would tend to stand by itself, would it not? I mean, that if in the future, irrespective of whether we make a statement in our finding, that if they apply as a for-profit pharmacy still associated or owned by this nonprofit, they're not going to get a permit. But what would happen if Lumicera got spun off and then Lumicera applies for a permit, but yet we've said you can't have one, but yet then they're simply a for-profit pharmacy?
Yeah, I don't think this board can bind a future board.
Okay, I'm just making sure that
So I don't think.
so the finding would be that at this time, they cannot be approved to have an out-of-state pharmacy permit. Anything else? We go back on, do you want to make that motion?
Yeah, I'll do it.
Ready to go back on then, board?
Yes, sir.
All right, we're back on the record. I believe the board has reached a decision.
Okay, I'm going to make a motion in the matter of Lumeris Health Services LLC, case number 2023-124. And I guess, yeah, it's just for this case. We're gonna have to act on the
This
other
is just this case.
Yeah. That the board make a finding that the allegations A1 through A11 have been proved. We state that we're relying on the applicable law and regulations as stated in L1 through L4. And we're finding charges C1 through C3 proved. And we're taking the action that we're finding that Lucera is ineligible to hold a pharmacy permit.
Out-of-state pharmacy permit in the state of Arkansas.
I'm sorry.
Out-of-state pharmacy permit.
Yeah,
in the
not
state
state
of-
pharmacy.
Okay, we have a motion by Mr. Simpson. Is there a second?
I'll second it.
Second by Dr. Newsom. Is there any further discussion on the motion? Hearing none, all those in favor of the motion, please signify by saying aye.
Aye.
Any opposed?
Aye.
We have one nay and one abstention. Motion passes.
All right. Is there any other business we need to tend to in this hearing?
Yes. Dr. Richmond, so typically we have to say if this is going to be reported anywhere, do we even need to worry about that since they just gave up their license or reported to the database or not? We typically decide that.
There's discussion going on here.
Your microphone is off.
Your microphone.
But sometimes the button doesn't even work.
So are you wanting this as a response on, because this is on the record with a question from the board?
I don't think they want me to talk on the record.
No.
I don't object to Dr. Curley addressing off the record.
So
Let's go off the record then.
okay, so the way that I think we would look at this is they had already surrendered their permit. So it could be determined disciplinary action that they were told they were not eligible for a permit because of especially, C1, C2, C3. We're going to have to look at exactly how that would be reportable. I don't know that it's a question I can actually answer right at the moment.
Okay, I just didn't know if we needed to decide that or if that.
Well,
If-
the thing is, this is not a consent agreement. This is a contested hearing. So it doesn't throw it into the board trying to say, is this a disciplinary or non-disciplinary consent agreement? It's just the facts of the case itself and the findings of fact and how we have to report that to the data bank.
Okay, perfect.
Yeah, the Board of Pharmacy doesn't set the standard on a contested hearing generally on what is or is not reportable. We have to look at the data bank requirements.
Thank you.
Council, do you have anything?
I'm in trouble now. No, nothing to add. I actually tried to do it that time and didn't.
All right, well, let's go back on the record for a moment. All right, we're back on the record. The administrative question was resolved. The board has made its decision and has voted on the record. You're aware of your appeal rights under the APA. You have counsel that can do that. You have the time period under the APA to appeal this decision to the Pulaski County Circuit Court. And with that, are there any other matters for this case that we need to address? Counsel?
No, sir.
Counsel for the board. All right, with that, we are going to close the record in 2024, or correction, Lou Macera Health Services, case number 2023-124. go back on the record.
Well, I think they're gonna take a break.
Hey, you want to take a break? Okay, let's take,
10 minutes.
till, can we do till 45? Work.
Yes.
Yes, sir.
This is 2025-08.
All right. We still have our remote attendees on or?
Yes.
There we are. All right. Okay, let's go on the record. We're now going to be doing case Lumicera Health Services LLC, case number 2025-008, which is being heard before the Arkansas State Board of Pharmacy. Today is February 12th, 2025. As I said earlier, please silence your cell phones. And for the respondent, and I guess this is a declaratory order. Is that what this is?
Yes, sir, that's correct.
All right. So if you would go ahead and identify yourselves for purposes of this record, please.
Good afternoon, Casey Castleberry here on behalf of Lumicera Health Services. And I appear here with Tyler Gerst, also from Lumicera Health Services.
All right. And let's see, you've got the order and notice of hearing for today and you're appearing here. Are you ready to proceed in this matter?
We are ready to proceed.
All right, counsel for the board, please identify yourself for purposes of the record.
Ashley Vales, General Counsel for the Arkansas State Board of Pharmacy.
Okay. We just went through this, but for purposes of this record, for anyone present here today who's not appeared in an administrative hearing, the board will base its decision on the evidence and arguments presented today. This hearing is held under the Administrative Procedures Act, which means the strict rule of evidence do not apply, and the parties will be given latitude in introducing evidence and argument to promote fair hearing and provide the board with adequate information to make a decision. To ensure efficiency in the proceedings, I'll grant objections or caution the parties only as necessary. If there's anything that you have in your possession that you want the board to consider, you must offer it into evidence today. And then all participants to the hearing should be aware that these proceedings are subject to the Freedom of Information Act, and all parts of the hearing, including the deliberations of the board, are open to the public. It's important that all persons necessary to the hearing in the room during the hearing. If party or attorney or board member needs to take a break, let us know. We will do so. And are we going to put testimony in this case, or are we just incorporating the prior testimony?
We will incorporate the prior testimony. I'll be happy to announce what I believe is a stipulation on that whenever appropriate.
Guess what I'm asking is there any witnesses I'm going to need to swear in for the purposes of this hearing?
No, sir.
All right. And with that, let's move to the preliminary matters and explain to the board what we're doing, and then also move to introduce all the evidence from the prior case.
Thank you, Mr. Hearing Officer, Chairman, board members. This case is a related case and involves substantially the same issues as the case the board just heard. On December 16th, 2024, on behalf of Lumicera Health Services LLC, I filed a petition for declaratory order under this board's rules, wherein I sought from this board a declaratory order that Arkansas Code Annotated Section 17-92-607A does not apply to Lumicera, as no hospital has an interest in Lumicera or holds directly or indirectly an interest in Lumicera. Also sought a declaratory order pursuant to board rule 01-00-0008 that Arkansas Code Ann 17-92-607A violates the equal protection clauses of both the United States and Arkansas constitutions. We have an agreement among the parties to introduce into evidence all of the exhibits and testimony from the hearing that just concluded in case number 2023-124. We have no additional proof to offer. I understand the board's ruling in the previous case directly addresses at least the first issue in this case. The second issue in this case is a constitutional issue, which frankly, we have to raise to this board, but the board doesn't have the authority to pass upon. So it's an odd scenario, but a box we have to check. So with that, we would submit this issue to the board based upon the record previously created in case 2023-124.
Yeah, I just want to add one thing. We would like the board to take judicial notice of Dr. Kirtley and Mr. Gross's testimony in the previous case. Mr. Castleberry's provided a written petition for declaratory order. I've provided a response and exhibits, many of which are the same exhibits that you looked at in the previous case. But beyond that, I have no additional evidence to present.
And we have no objection and agree to the previous testimony being made a part of this case. And we agree that the filings, both our petition for the declaratory order and the board's response and all exhibits to those filings be made a part of the record as well.
And so just to be clear, all the testimony, evidence, and rulings from the prior case were making a part of this case. You are addressing the issue of the statute, but then you have a secondary issue you wish to argue related to the constitutionality for the board, recognizing the limitations of the board, but to comply with the requirements for you to be able to take this up, correct?
Correct. And I would suggest, and merely my thinking of how to make this the most efficient would be for that the board would make two votes. One that would, based upon its previous ruling, would deny the declaratory relief in count one, and a second motion that would simply state that this board doesn't have the authority to pass on constitutional issues raised.
Counsel for the board, do you have any comment in response to that?
No, I agree with that assessment and plan of action.
All right, counsel, I'm counsel for the, since I guess actually you're like the petitioner in this one, go ahead.
I am the petitioner, and I would rest upon the arguments made. And if I didn't say this earlier, I would also incorporate those arguments as well as evidence from the previous proceeding into this proceeding, so you don't have to hear the same spiel again. You've heard it, and I appreciate your time in doing so.
And for purposes of the record, that the testimony, evidence, and arguments are admitted into this file.
Correct.
Do you have any arguments you wish to make on the constitutional aspect of it?
I have nothing further to add that's not in my petition. Thank you.
All right, thank you. Counsel for the board, do you have anything?
Likewise, I've moved all the exhibits and testimony from 2023-024 be admitted into evidence. And my written response to Mr. Castleberry's petition and those exhibits, and ask that the board, consistently with what the decision was in the previous case, deny the petition and find that the statute does apply to Lumicera's corporate structure. With regard to the equal protection arguments and constitutionality of the statute and how it's applied, I would ask that the board simply deny that, because as a member of the executive branch sitting here, you have no authority to rule on the constitutionality of a statute.
All right, with that, are there any questions of the board before we go off the record to deliberate? Remote board members, do you have any questions before we go off the record to deliberate? Seeing none, we're going to go off the record.
It's pretty straightforward. Seems to me we deny the petition. We adopt the brief that the agency submitted setting out its reasons. And I would suggest, in order to bolster our interpretation, that we make some additional findings regarding the relationship between SSM and the nonprofit hospitals and Lucerna.
What do you mean?
I would say that as far as the basis for our decision, there was a violation of, what is it, 1792-607A. That's the one, isn't it? Now I'm having trouble seeing it. Yeah, 1792-607A, that it relates to the relationship between SSM and the nonprofit corporations and Lucerna, in that SSM exercises control and influence over all subsidiaries and have aligned interests and goals set by SSM, and that's sort of the sort of things that went along with the questions that I asked before.
Does the board have any concern or questions about that embellishment?
I'm just thinking it's important that we flesh out since the basis of what we're deciding is being attacked. I think it's important that we flesh some of that out. greater detail than might otherwise be there.
You want to?
Yeah.
Go back on the record. You want to make that
Yeah.
motion? All right, and it's Lumacera.
Lumacera, okay, I'm sorry.
There were, I think there's two issues. There's the issue related to the declaratory order petition, we deny that, and then there's the second one related to the constitutionality, just for purposes of a clear record for them to take this up.
Yeah, and we're adopting the response of the agency for saying that all statutes are presumed constitutional. It's their burden of proof and so forth. I don't think we need to get into arguing that at all. But I do think we need to provide a basis for our interpretation of the rule.
Any other discussion?
I'll just, because we've had so many different numbers that we've been cited, Harold, are you sure that you're picking the right one that you're wanting to talk about? This 169207, whatever.
Yeah. 1792-607A. I think that's it.
Are you ready to go back?
We're ready?
Yes, we're ready.
Go back on the record. I believe the board has reached a consensus. Board?
Mr. Simpson, you.
Yeah, I have a motion in the matter of Lumacera Health Services LLC, case number 2025-08. I move that the board deny the petition for declaratory order and adopt the response to petition for declaratory order filed by the agency staff in this matter. With regard to the issue of my kingdom for a written document. With regards to the board's interpretation of Art Code and 1792-607A, the board bases its interpretation on the relationship between SSM Healthcare Corporation and its nonprofit subsidiary hospitals and Lumacera Health Services LLC, to the extent that SSM, that's SSM Healthcare Corporation, inherently exercises control and influence over all its subsidiaries with regard to such things as strategic decisions, overall vision, resource allocation, and that such influence affects all subsidiaries, even with or without any direct organizational link. And it is through SSM that the interest of the hospitals in Lucerna Health Services arises. That's further bolstered by the fact that subsidiaries have aligned interests in the overall goals set by SSM. The success of one subsidiary can contribute to the overall success and reputation of the group, including this other subsidiaries. That common ownership facilitates resource and knowledge sharing, and brand and reputation association of one subsidiary can affect the other subsidiaries. And it's for those, among other reasons, that we've determined that there is sufficient interest to link the nonprofit hospitals and Lucerna as required by Art Code and 1792-607A. And as far as the constitutional, we responded to that by adopting the agency staff's response.
All right, we have a motion by Mr. Simpson. Is there a second? So a second by
A
Dr.
second.
Newsom. With the motion, is there any further discussion on the motion? Hearing none, then all those in favor of the motion, please signify by saying aye.
Aye.
Any nays? Motion carries.
Mr. Castleberry, I believe you understand the ruling of the board. Do you have any questions? And counsel, do you have any comments or questions for that? We're going to close the record. You understand your right to appeal circuit court on this issue and the decision of the board. It'll be reduced to writing for you. And with that, we'll go off the record. Yeah, let's take a 10-minute break. They're trying to negotiate on a case or do something.
Beth Ann and Debbie, we're going to take another 10-minute break. We have to meet with other folks here real quick to start back up.
All right, I'm ready. Which one do you want to, let's start with. Okay.
And if you just. I can just go through the exhibits real quick and. Okay.
Thomas K. I think I left one.
Here's a pen.
All right, my remote members can hear me on the microphone if you'd nod your head. So what we're going to do is we had the 1 o'clock drug crafters. They're still negotiating back behind, working on some details. We're going to move back to the 9 a.m. no-shows for the CE violations. And the first one we're going to do, if I'm correct, is the Thomas K. PD 12095, case number 2024 CE-22. Is that correct, counsel?
It is correct.
All right, with that, we're on the record and let the record reflect that the respondent was not present this morning at 9 a.m. It is now 3:25 in the afternoon and the respondent is still not present and the board is ready to move forward with their case. Counsel for the board.
I asked that the board take judicial notice of the applicable statutes and rules regarding this matter that are outlined in the order of notice of hearing. I'm going to briefly call Dr. McCready and otherwise rest on the record after her testimony. Call Dr. McCready.
You would raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, Dr. McCready, you did the audit for Thomas K. PD 12095, correct?
That's correct.
Tell me what the audit results showed.
Dr. K had 41.5 home study hours. He had 0 live hours. The Arkansas State Board of Pharmacy rules and regulations require he have 12 live hours for renewal, which he did not have. We sent him a consent agreement. I did not get a response. I sent him another consent agreement. He did respond with an email that's under Exhibit 4 stating that he was not able to get live hours because of COVID from 2020 to 2023. Live venues and public gatherings were discouraged by health leaders and the CDC, so he relied on clinically accurate and up-to-date resources for requirements of continuing education. Lastly, he said he has entered retirement, no longer plans to practice, and he's considered this matter closed. We sent him an order notice of hearing, which is under Exhibit number 2. We have a proof of service under Exhibit number 3, where it was signed for by Janet K. And under Exhibit number 5, again, is that initial audit response. That's it.
What's the board staff's recommendation with regard to the order notice of hearing on Thomas K?
Staff recommendation is that we follow our standard policy and procedure, that he be fined $100 per hour that he's short. Which would be $1,200. He would have to make up twice the number of live hours short, which would be a total of 24 hours. And that if he does not do that, he does have the option to surrender his permit, but the fine stays and we fine him the investigational costs at $100 per hour.
How much investigation hours have you?
This one probably
Done.
had about 6 hours.
So you're asking for $600,
yeah.
so $1,200 fine, make up 24 hours of
Live CE.
live CE
Yeah.
with the option to surrender if he doesn't want to make up the hours.
But
But the fine remains and $600 in investigative costs. Is
That's
that correct?
Yes.
That's all I have for this matter.
You move to introduce the exhibits.
I do move to introduce the exhibits 1 through 6. 5, sorry.
The exhibits are admitted and respondents not present. Board, do you have any questions for this witness? With that, do we need to go off the record to deliberate?
Just for a moment.
All right, let's go off the record.
So if the board's okay with this, just in the efficiency of time, I was going to ask Dr. Jolly if, as we approach each one of these, to just make the motion, and then one of y'all could second if you don't mind. Is that okay with you, Dr. Mack, Dr. Davenport? Okay, we're ready to go back.
All right, we're back on the record in case number 2024 CE-22, and I believe the board has reached a consensus.
I'd like to make a motion in the matter of Thomas K. PD 12095, case number 2024 CE-22, allegations 1 through 4 having been proven, are true. Charges 1 and 2 are proven. Make a motion that we adopt board staff recommendations and require 24 hours of live CE, $100 per hour fine, which comes to a total of $1,200, and then $100 per hour for investigative costs, which comes to $600 due June 15th of 2025.
A motion on the floor. Is there a second?
I'll
Dr.
second it.
Newsom, second. So any further discussion on the motion? Hearing none, all those in favor say aye.
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 All opposed? The ayes carry the motion.
Just let the record reflect the vote was unanimous. And with that, for purposes of the record, the respondent has the opportunity to appeal this decision according to the APA within the time periods of the Administrative Procedures Act. And if there's nothing else, we will close the record in this case. We're closed.
Right, I'm gonna, case be on, yes, thank you. Move to admit into evidence exhibits 1 through 6.
All right, let's get on the record and we'll do that.
Oh, sorry.
That's all right. Okay, we're back on the record in case of Ansong Taku PD 12710, case number 2024 CE-37. Please let the record reflect that the respondent was not present at 9 a.m. this morning. It is now 3:30 in the afternoon and the respondent is still not present. Counsel for the board, are you ready to proceed?
I am.
Would you go ahead?
I move to admit into evidence exhibits 1 through 6 and ask the board members to take judicial notice of the applicable pharmacy rules and statutes governing this case, which are outlined in the order of notice of hearing.
The exhibits are admitted and you may continue.
Ask to call Dr. Brenda McCready.
If you would, please raise your right hand. You swear affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth.
I do.
Dr. McCready, as part of your duties as Assistant Director of the Arkansas State Board of Pharmacy, did you conduct a CE audit on Mr. Taku, PD 12710?
I did.
And what was the result of the findings?
Dr. Taku had a total of 15.75 hours. He was short a total of 16.25 hours. He was short 3.75 live and 12.5 home study. We mailed him a consent agreement. He did not respond. He did eventually start corresponding back and forth with me. I've spoken with him a couple of times and had contact, as has the attorney, as of last week. We sent him an email on Friday telling him that we would need to have his consent agreement into the board by this morning so that we would not have a hearing. We have not received that at this time. It is board's recommendation that he be fined $1,625 for the continuing education that he's short, make up twice the number of hours, which would be a total of $3,250, 7.5 of those being live.
And are you asking for investigative costs?
Investigative costs would be 8 hours on this one, which would be $800.
Anything else you want to add with regard to Pharmacist Taku.
Dr. Taku did tell us he did not want to surrender his license, and that he would get this taken care of, and that obviously has not happened.
The rest.
All right. Does the board have any questions for this witness?
Just one quick question, Dr. McCready. Did you say 32.5 hours total, 7.5 live?
Yes.
Okay, thank you.
One last question. Sorry.
Question?
The question just is, all these others wanted to give up their license. This one doesn't. Does he get to keep working, I'm assuming, until he takes care of this, or how does that work?
He is not currently working at this time.
Oh.
The board can make a stipulation that the permit or the license is suspended until such time as these requirements have been met. If they want to do that.
All right. The board is asking to go off the record for deliberations. We'll be off the record.
All right, so the considerations have been pretty consistent, double the hours, the amount of the fine, investigative costs, but now we're asking to be to consider whether or not their license be suspended until such time that the fines and penalties that have been levied are met. What's the board's consideration for that?
But he's not in the state of Arkansas, so. But he's a Harding, do you know him? Harding student? Okay.
I would be okay with suspending until he pays.
Right, yeah.
Yeah.
so it's done.
Do we want to take this approach with others, or why is this one of particular notice?
My concern was just that what if he goes another 6 months or 8 months and doesn't answer and doesn't pay? It's not so much the money, it's
Or put
the,
the June 15th deadline on here. So I think you're giving them time. If they don't by June 15th, what happens, I guess, would be the question. At that point, is their license suspended?
We may have to go back on the record and ask.
Let's do that.
We're gonna go back on the record. The board has a question administratively for staff.
If they don't comply with the terms by June 15th, what normally happens?
In the previous biennium, we actually did suspend. If, like, earlier this morning, he said, I want to surrender. So you said, okay, if he surrenders, then the hours are moved. But this gentleman has said he doesn't want to surrender. In the past bienniums, we have done the fine, the double the hours, and we've suspended until they met those requirements.
Repeat that.
We
last
did,
part
we
again.
did not do that this morning, right,
We
with
did
the
not do
first
that this morning,
woman?
but that has been the standard procedure up until this morning.
So repeat
Okay.
what the procedure is one more time.
$100 per hour, investigative cost, twice the hours missed, suspend till this is taken care of. Till this board hearing order is resolved.
But if they sign a consent agreement, they can continue working.
If he signs
until
a
they-
consent agreement, he could continue.
Any other questions of staff at this point? We're gonna go back off the record then.
So how do you?
Board okay with that?
So the way I word that is, if he's not willing to sign a consent agreement, we're gonna suspend his permit.
He's already passed the point.
He's past the point of that. Okay.
I think at this point, we were doing the hearing and you impose the sanction. It's suspended until he takes care of it. Otherwise, his license is just.
Okay. Yes.
Back on the record, I believe the board has reached a consensus.
Dr. John?
In the matter of Asante at the coup, PD 12710, case number 2024, CE-337. The board finds that allegations 1 through 4 are true. Charges 1 and 2 are proven. I'd like to make a motion that we issue a $1,625 fine. That's $100 per hour of every CE hour that he's short, that he make up 32.5 double the number of hours that he's short, 7.5 of which need to be live CE, and impose a $800 investigative cost. Also make a motion that we suspend the permit until the fines and the CE requirements are resolved.
All right, we have a motion on the floor. Is there a second?
A second.
Dr. Newsom, second. Any further discussion? Hearing none. All those in favor of the motion, please indicate by saying aye.
Aye.
Any opposed? The ayes have it. Motion carries.
Please let the record reflect that the vote was unanimous, and for purposes of the record, respondent cares to appeal this decision. The appeal can be filed under the provisions of the Administrative Procedures Act and the time period therefore. We are closed on that matter.
I want to call how do you say that?
Masa.
Masa Shabaniya. For CE 33.
Okay, we're here in the matter of the Arkansas State Board of Pharmacy and Masha Shabina, PD 15069, case number 2024 CE-33. Today is February the 12th. Please let the record reflect that the respondent was not present at 9 a.m. this morning when it was originally scheduled. It is now 3:38 in the afternoon. The respondent is still not present. Counsel for the board, are you ready to proceed? All right, if you would go ahead with your exhibits and then we'll swear in your witness.
I move to admit into evidence exhibits number 1 through 6. Ask the board members to take judicial notice of the applicable pharmacy statutes and rules governing this. They are outlined in your order of notice of hearing.
The exhibits are admitted. If you would have your witness raise your right hand. You swear or affirm the testimony you'll give will be the truth, the whole truth, nothing but the truth.
I do.
You may proceed.
Dr. McCready, did you do a CE audit on Dr. Shabinia?
I did.
And what was the result of the audit?
Dr. Sabina had 9.5 home hours and 0 live hours. She was sent a consent agreement requesting that she sign a consent agreement and make up twice the hours that she was short and pay a penalty. I actually did not hear back from her. We sent the order to her and it was returned as undelivered, but we do have proof of the attempt to serve under exhibit number 3. Under number 4 is the initial, one of the emails that I sent to her regarding her continuing education requirements, stipulating that she was short 12 live, 8.5 home study, and that she would need to pay a monetary fine of $20.50 and make up the hours, twice the hours short.
Did we send the notice of today's hearing at her address that we have on file for her at the board?
We did, and her address of record is exhibit number 6.
All right. What's your recommendation?
Recommendation is that she make up twice the number of hours missed, which would be the balance, she pay a penalty of $22,050 with a 4-hour investigative cost. And the reason that's less is because there was no response from her after I started the initial contact. So at that point, I just set it into the file to come before the board. She would have to make up 24 live hours and 17 home study and suspend until those have been, this agreement has been completed.
You rest.
Board, any questions for this witness?
No.
All right, shall we go off the record for deliberation?
We're good.
All right, let's move on.
I'd like to make a motion. In the matter of Masa Shabanina, PD 15069, case number 2024 CE-33. The board finds that allegations 1 through 4 are true. Charges 1 and 2 are proven. I'd like to make a motion that we issue a $2,250 fine for each $100 per hour for each hour of CE that she was short, $400 investigative cost, and has to make up 41 total hours, 24 of which must be live. And that we suspend the permit until these requirements are met.
2050.
2050.
Yeah, 9.5 hours.
Okay, I'll amend the motion to the dollar amount is 2050. Sorry.
Okay, we have a motion on the floor. Is there a second?
I'll second.
Dr. Newsom, second. Is there any discussion on the motion? Hearing none, all those in favor of the motion, please signify by saying aye.
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 Any opposed? The ayes carry it. Unanimous.
For purposes of clarity on the record, it was $2,050 in fine plus the $400 in investigative costs for a total amount of $2,450, correct?
That's correct.
All right. And did you include a deadline for that to be paid by?
The permit is suspended until it's paid.
All right. The board's decision was unanimous. Council, do you have anything to add?
No.
All right. With that, I will make my statement. Respondent has the opportunity to appeal this decision according to the Arkansas Administrative Procedures Act and with the time period therein. This case is now closed.
Or Janelle Jackson case.
We're on the record in the Arkansas State Board of Pharmacy in the case of Janelle Jackson, PD 13744, case number 2024 CE-19. Counsel for the board, let the record reflect that the respondent was not present at 9 a.m. this morning. It is now 3:44. Respondent is still not present. Counsel for the board, would you like to proceed?
Yes, I would move to admit into evidence exhibits 1 through 5. Ask the board to take judicial notice of the applicable pharmacy statutes and rules that govern this matter that are outlined in the order of notice of hearing.
The exhibits will be admitted. Would the witness please raise your right hand? Do you swear or affirm the testimony about to give will be the truth, the whole truth, none but the truth?
And can you state your full name?
Brenda McCready, Assistant Director, Arkansas State Board of Pharmacy.
And as part of your duties, did you do a CE audit of Janelle Jackson's hours?
I did.
What was the result of your investigation?
Dr. Jackson had 37.5 home hours and 1 live hour, which meant she was short 11 hours. We sent her a consent agreement. It was returned to the board. I actually found a different address through a different licensure file at a different state and attempted to contact her that way. It was returned to the board. So we did set her up for a hearing. There was a proof of attempt to delivery under exhibit number 3. It was also returned to the board. I've spoken with her one time on the telephone. She was short 11 hours, which would be $100 per hour, would be $1,100, $400 investigative costs, and suspend until do my recommendation. Oh, she'd have to do 22 live hours.
Is that your recommendation?
It is.
Else you want to add?
It is, no.
Rest.
Board, any questions for this witness?
You said how much for investigative costs?
400.
We're ready.
In the matter of Janelle Jackson, PD 13744, case number 2024 CE-19. The board finds that allegations 1 through 4 are true. Charges 1 and 2 are proven. I'd like to make a motion that we issue a $1,100 fine, $100 per hour for each hour of CE hours that were short, plus $400 investigative cost for a total of $1,500, and that the respondent make up 22 CE hours, all of which must be live. I make a motion as part of this motion also that we suspend the permit until these requirements have been met.
I'll second that motion.
Okay, we have a motion and a second. Is there any further discussion? Hearing none. All those in favor of the motion, please signify by saying aye.
Aye.
Any opposed? The ayes carry it.
All right, let the record reflect the vote was unanimous. For purposes of the record, the respondent has the opportunity to appeal this decision to the Pulaski County Circuit Court according to the Arkansas Procedures Act and the time limits therein. With that, we will close this case.
all we have on this sheet we need.
We have a consent agreement.
So that case, we don't need to call.
Does that take care of our agenda?
No.
No, we gotta do the factors, I think there's a.
And we're off the record for purposes of my Zoom members. We have the drug crafters case that I believe there may be a motion that you will get to decide. We're working that out right now.
Hey, can I ask just a general question, non-record at all?
Sure.
So like what happens, so if we have these fines that go out to people that sometimes respond and sometimes don't, or what have you, like what happens if they just don't pay the fine, but they're not working in Arkansas? Like, does it get turned into some higher
So
authority or credit
from the
agency or
board-
something?
From the board staff side, all of these orders are actually disciplinary orders at this point, so they will be reported into the National Data Bank system. We offered non-disciplinary routes to go with this, but if you're unresponsive or refuse to respond or just don't show up after all of these months of Dr. McCready doing that, that's when we have this hearing. Since it's disciplinary, it goes into the data bank. If they never pay, they never get their license back with Arkansas. It just stays suspended forever. At some point, we would look at that basically as uncollectible debt and then write it off so it gets it off of our books because it's uncollectible by the state agency. Otherwise, it looks like we are missing money on our books, basically, just like other businesses would write off bad debt.
Got it.
So it's,
Thank you.
I had a conversation with, Lane a while ago, like we've got some that are large amounts of money and the people decide just to disappear forever. If we don't get the money, we don't get the money. So real quick, Ashley assigned me, I think she's coming back in here. But did you guys decide June 3rd and 4th or June 10th and 11th?
Overdue that message.
Here in a minute, Ashley's about to say we might need both dates. So
Which month are we talking about?
June 3rd and 4th. I mean, if that works, we can do that. That'll give us an extra week before APA. If people want to go to both, it might be easier to get a little block and a little block. Does that work for everybody? June 3rd and 4th. And then for April, we were looking at April 16th and 17th or 23rd and 24th.
I know we all don't have to come. I definitely won't be here that date, so y'all talk
Okay.
about that amongst you.
It'd be informal as long as we can get like 4 folks. April 16th, 17th, or April 23rd, 24th for informals. We've got applicants and some med-error case and stuff backing up on us. So are you saying you want us to have it then or you don't? 23rd, 24th? Okay, we'll do that. That work for you, Counselor? All right.
We're ready to go on the record.
You'll need a blue.
Okay, we're in the record, or on the record of Arkansas State Board of Pharmacy in the case of Drug Crafters OS 03125, Aaron Thompson, PD 16483, case number 2024066. Today is February 12th, 2025. For those who just entered the room, please make sure your cell phones are on silent. And I believe there's a preliminary matter that we need to address. Is that correct, counsel?
Yes, we have a joint motion to continue this matter until our next board meeting, which I now know is June. Well, in this case, it would be June 4th. So we ask that the board allow us to continue this matter. There's some other issues that we need to work out before we can actually adjudicate this case.
Counsel for respondent, if you would identify yourself, say and spell your name for purposes of the record, and then just respond to.
Yes, happy to. Is my microphone on?
It is.
Yes. David Mitchell, along with my colleague Ryan Smith of the Rose Law Firm on behalf of the respondents in this matter. And we agreed to the motion as stated by counsel for the board. Plenty to discuss amongst us, but also this is not a matter that will be able to be presented this afternoon, even if we wanted to go forward. And nobody wants to be here till midnight. So that is our motion if it meets the pleasure of the board.
So at this point, there's a motion to continue. It's the decision of the board to continue this matter to the June 3rd meeting, is that June 4th meeting? Or you can make them go forward and whatever, but it's up to the board at this point.
Who wants to make the motion? Dr. Newsom?
I'd like to make a motion that we accept their continuance and set the new date for June 4th, 2025.
Here we have a motion on the floor. Is there a second?
Second.
Second by Dr. Jolly. Any further discussion? Okay. Do we have one refusal? Hearing no further discussion, all those in favor of the motion, please signify by saying aye.
Aye.
All opposed? One recusal by Dr. Boone.
All right, at this point, this matter will be continued until June 4th. A notice will go out with the date and time prepared by counsel for the board. And with that, we'll go off the record. You have anything else? Paul?
I do not.
And unless we have any additional,
I have nothing additional, just a heads up. One of our folks this morning is trying to find out how they can email board members directly. So we will do our best to handle that through counsel. Just a reminder, if you have people that have a hearing or just had a hearing that are trying to contact you, I would probably reach out to legal counsel on that matter so that you avoid ex parte communication.
Okay.
That's it.
Did we
Thank you
do the
guys so much
intern
for being here.
application? John,
Debbie, the intern, Darren O'Quinn asked for a continuance, so they're gonna come in June as well. Since
Okay.
everyone else, I guess we're done. Did they actually close the meeting or just?
I don't know.
Well, let me.
Are
go
we like
check.
all the way done?
I don't know, because usually they actually close it. So let me go and actually check, and if so, then I'll nod and cut it off. Thanks.
Thank you.
Thank you.
So when is your stuff in June? When will your students start?
They'll start the day after Memorial. So they'll be at our next meeting in June.
Okay, all right. It's just a meeting. All righty.
Thank you. Nice to meet you guys. We should be under different. That's the story of my life.
I think we're done, huh, Beth Ann?
Did we get a nod?
Oh, but they closed it off.
Goodbye.
Bye.